along the way, but just in the interest of time. Good afternoon and good evening. My name is Stanton, and I am the current director of the Center for Middle East Studies at the Korbel School of International Studies at the University of Denver in Colorado. On behalf of my colleagues here and on behalf of our co-sponsors, the Center for Judaic Studies and the Department of History at the University of Denver, I'm very happy to welcome you to today's webinar, The Occupation of Justice, the Supreme Court of Israel and the Occupied Territories. We are very happy to have you all here with us for a discussion with Professor David Kretzmer, Professor Yaël Ronen, and Raja Shehadeh, who will provide a critical analysis of the manner in which the Israeli Supreme Court has dealt with petitions relating to the actions and policies of the Israeli authorities in the West Bank and Gaza. Also examine impact on the legitimation of Israeli policies in the occupied territories. It is now my pleasure to introduce our moderator and our discussant for today, Dr. Micheline Ishay. She is Distinguished Professor of International Studies and Human Rights at the Korbel School, where she serves as Director of the International Human Rights Program. She is the author or editor of many books, including The History of Human Rights from Ancient Times to the Globalization Era, and The Human Rights Reader, Major Political Essays, Speeches, and Documents from Ancient Times to the Present, which have been translated into multiple languages. Her most recent book, The Levant Express, The Arab Uprisings, Human Rights, and the Future of the Middle East, was published by Yale University Press in 2019. I'm going to turn the floor over to her to introduce our panelists, but I would also just first note for those of you who have joined us for today, we will take questions through the Q&A box that you should be able to see towards the bottom right of your Zoom screen. The questions will not be visible, I believe, to the audience, but the host and panelists will see them. And then when we reach the Q&A section for today, then we will read them out. If we don't have time to get to your specific question, we apologize, but we will get to as many as we can in the time that we have. So Professor Ishay, I will turn the floor over to you.
Thank you, Andrea, for this very kind introduction. It's really my great pleasure to introduce our distinguished panelists who will comment on the recent book by David Kretzmer and Yaël Ronen entitled The Occupation of Justice, the Supreme Court of Israel and the Occupied Territory. This is a book that just was published in 2021 by Oxford University Press. Both authors are with us this afternoon, together with Raja Shehadeh, a renowned Palestinian lawyer and author who will comment on the book. This book could not be more timely, given the recent controversy over land grabbing, and attempted evictions in Sheikh Jarrah, which led to the conflict between Hamas and Israel this past spring and the summer. I'm going to start it with one speaker at a time, so you'll remember who the person is as they speak. I will start with David Kretzmer by alphabetical order, and also because he wrote the first edition of this book. He's a Bruce Wayne Professor in International Law, Professor Emeritus at the Hebrew University of Jerusalem. In 1993, Kretzmer founded the Center for Human Rights at the Hebrew University and served as its first academic director. From 1997 to 2000, he headed the Minerva Center for Human Rights and a joint center between the Hebrew University and the University of Tel Aviv. Professor Kretzmer was among the founders of B'Tselem and the Associations for Civil Rights in Israel, and was a member of the UN Human Rights Committee from 1995 to 2002, serving as a vice chair from 2001 to 2002. He has appeared before the Supreme Court of Israel in human rights cases, and his books include the first edition of The Occupations of Justice and the Legal Status of the Arab in Israel. And for those of you who have not seen yet, it's sort of behemoth book, which will probably become a classic in this field. I just strongly recommend you to read it. It's fascinating. So the stage is yours, David Kretzmer, and we will move after to Yael Ronen.
Thank you very much. And thank you very much for Micheline for that kind introduction. And I want to start with special thanks to Raja Shehadeh, who's with us today, and to admit that I have a real debt to Raja, because actually he was the first person to write a critical study of law in the West Bank when he published in 1980, The West Bank and the Rule of Law. And I met him the first time when he came to give me a copy of that book. And I think that reading that book is possibly what set me off on the path of going into the questions of law and the occupation, and eventually writing the first edition of the book and the second edition of the book now with Yael. But Raja has not only written about the questions of law, he has chronicled the occupation scene, of course, of the Palestinian living under occupation, beginning with his book, The Third Way in 1982, which was also an eye-opener. So we have an interesting situation here. Yael and I are Israelis, and we are members of the community whose country is the occupying power, and Raja, of course, is subject to the occupation of our country, and I really appreciate the fact that he is going to be here and discuss this book with us. Now, the occupation has continued for over 54 years. Our book deals only with one aspect of law and the occupation, and that is the role of the Supreme Court of Israel in reviewing actions of the authorities, generally the military authorities, in the occupied territories. When the court assumed this judicial review shortly after 1967, it was regarded as a precedent. There was no other known case of a domestic court or an occupying power exercising judicial review over the acts of the military in the occupied territories. But 54 years has passed since the court started its system of review, and we can now try to examine how the court has fulfilled this role, and that is what Yael and I have done in this book. Now, I think we have to consider the court's role with two fundamental issues in mind. And one of the first relates to the judges themselves, and I think it's very important, if we're going to understand the court, to note this from the beginning. Judges in Israel are independent. They are not going to be sanctioned for their decisions. They cannot be fired from their posts, but they are not neutral. And this becomes especially clear in an inherently unbalanced power situation of occupation, where their country is the occupying power and they are supposed to protect the rights of the people who are subject to the power of their country. The second issue is the two-faced attitudes of Israeli governments. When appearing before the Supreme Court, its own Supreme Court, in order to defend the acts of the military and other authorities in the West Bank and other parts of Palestine which have been occupied, and before it was Sinai as well, they have always relied largely on the law of belligerent occupation in order to justify restrictions of one nature or other on the Palestinians. But on the other hand, their policies and practices of all the Israeli governments since 1967 are not compatible with the same system of law. They are not compatible with the law of belligerent occupation. And the prime examples, of course, are the examples of the establishment of Israeli settlements on the West Bank, the taking of land for those settlements, the declaration of land as government land, and the use of this land for the purpose of settlements. So how has the court dealt with this situation? Well, at the basis of the problems of the occupation, in my mind, is the issue of settlements, which are largely regarded, and I agree with that, as unlawful under international law. But the court, from the very beginning, refused and has consistently refused to rule on the legality of the settlements in international law. It has also refused to rule on the use of public land for the establishment of settlements. Its argument was that these issues are fundamentally political issues. They are not suitable for a judicial decision, but obviously they were worried that if they made such a decision, whichever way they went, they would lose a large part of public trust of the Israeli public. And possibly even if they would decide that the settlements were illegal, the authorities would find some kind of way to overcome this decision and to ignore their ruling. But while they have refused to rule on the legality of the settlements, the court has legitimized settlements in many other ways, and perhaps Yael, when she comes into this discussion, will mention some of these tactics. But besides the issue of settlements, the court has consistently interpreted the law in favor of the authorities. It is in legitimized practices that are clearly incompatible with international law, and these include deportations and house demolitions. And it has also jumped from one legal system of interpretation or theory of interpretation to another in order to be able to justify the legal arguments of the government. So largely our main, I would say, conclusion has been that the function of the court in the end has been to legitimize the occupation, and to a large extent, if you want to say so, it has contributed its bit to the continuation of the occupation for 54 years, although there's no way of knowing what would have happened if the court hadn't have been there. But there is also a positive side, and that one has to recognize. While the court has not been prepared to rule against actual policies and practices of the government, it has been prepared on occasion to intervene in the way these policies and practices are implemented. And in many cases, rather than ruling, it has tried to pressure the authorities to modify their position in a specific case, and sometimes it's been quite successful. And in many cases, individual petitioners have been able to get a remedy either by court order or because the authorities have been pressured by the court to give them some kind of remedy. The court also serves as a forum to air issues and to force authorities to defend the issues, at least to try to make an arguable case under international law. And finally, before I hand over to Yael, we want to mention the one idea that we have in the book, that there's a shadow of the court. And the shadow of the court has a greater influence than the actual court itself. But what do we mean? That under the shadow of the court, there are quite a number of cases where issues are resolved without any involvement of the court itself, either by threat of legal action or by statements of lawyers in one of the departments saying that this matter will not stand up in court. So in the end result, the court has made some contribution to individual justice in some cases, but on the other hand, we do say in our book that the court has largely acted in legitimizing many of the policies and practices in the occupied territories.
Well, thank you very much, David Kretzmer, for this, the beginning of this conversation. So I'm going to turn to Yaël Ronen, who is a professor of law at the Academic Centers of Science and Law in Hod HaSharon. And she's a research fellow also at the Minerva Center for Human Rights at the Hebrew University. She has also a number of books that she's written that include the Court and the United Nations, the Iran nuclear issue, the transitions from illegal regime under international law. And I just noticed that a new book has come out of the bakery, and that is Strengthening Human Rights Protection in Geneva, Israel, the West Bank, and Beyond. Very much interested in that one as well. She's the academic editor of the Israeli Law Review, and before her academic career, Professor Ronen served in the Israeli Ministry of Foreign Affairs and was a member of the Israeli negotiating team for the Israeli-Palestinian interim agreement, the Oslo Accord. So Yael, it's your turn. Thank you.
Okay, thank you, Micheline, and thank you for hosting this event. Let me just say that Strengthening Human Rights is not a book that I've authored, but I co-edited. And in fact, it's it's a collection of articles published in honor of David Kretzmer. So an opportunity to mention that. Yeah. As David said, I will speak about one of the manifestations of the fact that the settlement project features so prominently in the court's decisions and the way that the settlements, the project affects those decisions. And the specific context in which we thought it would be useful to introduce this is the separation barrier. And I assume at least some of the audience is familiar with the notion, but just a few basic, some background information on it. So in April 2002, the Israeli government's National Security Cabinet adopted a series of decisions on construction of a barrier in the West Bank with the intention, and I'm more or less quoting, to prevent entry of terrorist activities from the West Bank area into Israel. Now, the total length of the barrier is close to 720 kilometers, which is over twice the length of the Green Line. And this tortuous route is about 85% of it runs through the territory of the West Bank, mainly in areas where Israel has established settlements and industrial zones. Now, the barrier was built with the security of Israelis in mind, and with no regard to the rights or the interests of the Palestinian population. So, for example, for the construction itself, large tracts of land were taken. 80% of them, more or less, are private land, and damage was caused extensively to olive groves and water wells. And in addition to the extensive taking of private land, and there's also limitations on movements and the rights that derive from it. So in many cases, the barrier impedes access of Palestinians to work, to schools, to medical facilities, and to other essential locations. And the barrier breaks up contiguous Palestinian urban and rural blocks. So it severely harms intercommunity ties. So from the beginning of the construction of the barrier until the late 2000s, close to 200 petitions were submitted to the court with regard to the construction of the barrier, both as a matter of principle and with regard to specific segments of it. And from the outset, the court upheld a policy of construction of the barrier within the West Bank, but it was willing to examine whether specific segments caused disproportionate harm to individual petitioners. So in its intervention in its first main case and in a handful of, as a result of its intervention in the first main case and a number of other cases, the authorities revised the entire route, and the area that is included on the so-called Israeli side was gradually decreased from over 16% of the West Bank to about 8%. And in many cases, the conduct of proceedings themselves led the authorities to revise the route. And this is what Dave referred to earlier as the shadow of the court. Now, given that the separation barrier was clearly determined with the settlements in mind, one might have expected that the court would have to rule on the legality of protecting the settlements and therefore on the legality of the settlements themselves, on their establishment. But in the Marabe case, the second of the two landmark cases, the court held that there was actually no need to decide on the status of the settlements as such, because regardless of that status, the military commander is obliged to protect the lives and safety of all individuals within the occupied territory. And that, said the court, was the purpose of the separation barrier. Now, politically, this framing of the question circumvented the thorny issue. But if we look at it closely from a legally, this analysis is not very sound. Because it's not enough that the purpose of the barrier is lawful in principle. And just to clarify, protection of the lives and safety of all the individuals in the West Bank, including Israelis, is not only lawful, but it's an obligation of the military commander. The issue is that the next question is whether the barrier in its specific route is lawful and the least injurious means of providing the protection that the military commander seeks to provide. And the state never considered any means of protecting the settlers other than by including the settlements on the Israeli side. And the court didn't demand that it do so. If the court had demanded that the state consider other options, the legal status of the settlements should have been highly relevant, because if the settlements are unlawful, relying on them cannot be a legitimate means of protecting the Israelis. And in fact, even if the settlements are lawful, the question remains whether less harm would be caused by removing the settlers back, relocating them back to Israel, or by maintaining them and causing harm to Palestinians. Now, these questions challenge the legality of the settlements in their location. And not surprisingly, the court did not consider either of these questions. But the matter went further. There were a number of cases when petitioners argued that some routes were chosen so as to accommodate not the existing areas of the settlements where people were already living and protecting the individuals within the West Bank, as the court said, but rather to protect areas slated for future settlement expansion, areas that were not inhabited. And essentially what the petitioners were arguing is that the separation barrier was protecting land rather than people. Now, the authorities denied this emphatically. They argued that whatever area was covered on the included on the Israeli side, again, so-called Israeli side of the barrier, was required for security, was determined on the basis of security needs. And the court invariably accepted this denial or this argument, which is not self-evident, because sometimes this depended on the court giving credence to security arguments by the government that ran contrary to the government's own declared security policy. And in some cases, this was difficult even for the court, and the court was quite explicit that it doubted the sincerity of the arguments. But then, rather than address the question of what is the true basis for the determination of the route, it struck down the route on the grounds that it caused disproportionate harm. So basically, it was saying, well, maybe it's lawful to maintain the route in the specific segment in a specific location, but the harm is disproportionate, therefore move the segment elsewhere, move the barrier elsewhere in this specific segment. Now, in this way, what the court did was it restrained the acts of the military authorities, but it didn't actually discredit their position as to their motivation in general or in the specific case. So the separation barrier we consider it to be a classic example of how the court legitimizes policies and practices on the one hand, but mitigates their consequences in individual cases. And it demonstrates the dominance of the settlement project, and specifically the repercussions of the court's refusal to consider the settlement's legality under international law. The separation barrier was tailored to satisfy Israeli interests, both those of the state and those of individuals, and that's incompatible with the obligations of the occupying power. This is not the court's making, but the consistently narrow confines of the court's review actually give the authorities free rein to implement these policies. In the book, we show a similar pattern in relation to other areas that the court considered, and we invite you all to delve into these topics. And of course, we look forward to any questions we may discuss. And before that, I'm looking forward to hearing what Raja has to say. Thank you.
Thank you, Yael Ronen. We're going to be moving to Raja Shehadeh. A brief introduction, although his CV and bio is really extensive. He's a Palestinian lawyer and a writer. He currently is living in Ramallah. In 1979, he co-founded Al-Haq, one of the first human rights organizations in the Arab world. He's a prolific author. He has published a number of articles in both law journals and magazines, The New Yorker, among others. I just was reading a few more of those articles just this weekend on the legal aspect of the Israeli occupation of Palestinian territories. His book on the subject include Occupation Diaries, From Occupations to Interim Accords and Whether the Line is Drawn. His book, Palestinian Walks, Notes on a Vanishing Landscape, won the 2008 Orwell Prize, which is the UK most prestigious award for political writing. His most recent book, Going Home, A Walk Through 50 Years of Occupation, won the 2020 Moore Prize as the best book advancing the understanding of human rights. And we are, of course, very privileged to have him here, and he will provide us a critical response to both David Kretzmer and Yaël Ronen's book on the occupations of justice. So please, Raja Shehadeh, have the stage right now.
Thank you, Professor Micheline Ishay, first of all, for giving me this opportunity to take part in this panel. And thank you, David, for your kind introduction and our common history, which starts in 1980 and has never stopped, really, because we continue to be in touch and we continue to be friends. I want to start by saying that I come to this not as a legal scholar or an academic, but as an activist who for some years had experienced the role of the Supreme Court's work on life in the occupied territories. In the early days of the occupation, the Israeli High Court of Justice represented to Palestinians a significant means of restraining the excesses of the military which controlled every aspect of our life, large or small. In the course of my human rights practice, the court often provided a deterrent from many of the excesses of the military's actions, as David has already said. But in time, this changed. Such was the disappointment with the court that many in the West Bank began dubbing it the High Court of Injustice. In his foreword to the book, The Rule of Law in the Areas Administered by Israel, which was a rebuttal of a law I wrote with Jonathan Kuttab called The West Bank, The Rule of Law, which David already mentioned, Justice Chaim Cohen, later the head of the Israeli High Court, wrote, quote, whenever any military or other Israeli authority exceeds its lawful power or threatens to do so, or infringes on the rights of any individual in any other unlawful way, effective redress by the court will be immediately available, unquote. In their fair, comprehensive, and well-researched book, David Kretzmer and Yaël Ronen described the court's legacy, its successes and failures, the hopes it engendered and disappointments it represented over the past half-century of its work on cases involving the occupied Palestinian territories. The work they produced, The Occupation of Justice, could be considered the definitive study of the role of the Israeli High Court and occupation. It should be read by anyone interested in the history of human rights protection under occupation. The route that this book negotiates so effectively is between the court as a vehicle for, in the words of the authors, providing the acts of the military authorities with a, quote, cloak of legality, thus rationalizing and justifying these acts, or carrying out the accepted twin functions of judicial review, namely imprinting government action with the stamp of legitimacy and that of checking the political branches of government, unquote. They provide evidence of how the court fulfilled both these functions and ask the crucial question, which of the two has been dominant? It was Maher Shemgar, who later became president of the court, who as Attorney General in the early years of the occupation wrote, the basic aim in accepting the court's jurisdiction was to enable some form of external control over the actions of the military so as to prevent arbitrariness and to maintain the rule of law. So initially, the grounds for accepting jurisdiction by the High Court over the actions of the military in the occupied territories were laudable. However, from the early days, the involvement of the court was exploited politically. As the authors point out, in defending Israel's actions and policies in the West Bank, the Israeli Ministry of Foreign Affairs regularly refers to decisions of the Supreme Court as evidence of protection of the rights of the local population, unquote. When we at the Palestinian Human Rights Organization, Al-Haq, began our human rights activism, the most common excuse for Israeli transgressions that we heard was that there was always the possibility of resort to the High Court. Presumably, this would mitigate any excesses, as though as long as this course was available to us, those living under occupation, all will be well. Many of those who answered the criticism in this way sincerely believed in what they were saying and felt proud of Israel and saw its occupation as enlightened, a contradiction in terms if ever there was one. Law students in the US universities over the years have used the High Court decisions as shining examples of how a court can protect human rights. But in time, the court eventually became one of the props in the large arsenal of Israeli propaganda arguments, whitewashing the occupation. It is a mark of shame that the court allowed itself to have that fate. Despite its ultimate dismal failure, many of the cases of violations by the military were resolved in the shadow of the court, as has already been said. The way this happened was that we would approach the legal advisor of the military and make it clear that if the violation is not stopped, we would appeal to the High Court in Israel. Concerned that there might be a precedent established, the military advisor would relent. This was not an insignificant deterrence in our hands, which otherwise would be completely tied. When the settlements were in their infancy, I and many others took every opportunity to warn against the consequences of the continuation of building more Jewish settlements in the West Bank, Eastern Jerusalem, and the Gaza Strip. More often than not, we would be told that Israel has offered the Palestinians under occupation the opportunity to resort to the High Court against the excesses by the military. In their eyes, this made Israel a model occupier conducting a benevolent occupation, and that it could do no wrong. And yet, sometimes the brilliance of the justices and their ability to come up with clever distinctions damaged the opportunity for the court to play a more effective role. This only increased as time went on. Such was the distinction Justice Landau drew between justiciability of the petition itself and the justiciability of a particular aspect of the matter. Such a distinction later became a central feature of the court's approach to the settlement question. The argument that settlements are per se unlawful is an aspect that is non-justiciable. In other words, the argument relating to the legality of the settlement under international law will not be entertained by the court. It was Maher Shemgar who, as Attorney General, had initially paved the way for the intervention of the High Court, who later, as President of the court in the Bergil case brought by the Israeli human rights organization B'Tselem on the legality of the settlements, ended up dismissing the case. The argument put forward by Justice Shehadeh as to why the case should be dismissed, which became the accepted position, rests on the argument that the legality of the settlement policy of the government is non-justiciable. This position rests on two connected grounds: non-intervention in a matter that is within the purview of other branches of the democratic regime, and maintaining public trust in the court. I had many occasions over lunch in Jerusalem with David to discuss this. On my part, I voiced my disappointment that the court failed to play a restraining role in this most crucial development, which is in violation of international law as the establishment of settlements in the occupied territories. David, who agreed with me on the politics, pointed out that the court has limits and needs to maintain public trust. In their book, the authors write that both grounds, the non-intervention and maintaining public trust, expose the inherent contradictions in judicial review of the court over the acts of its government in occupied territories. They later elucidate on this question when they write, the public trust in the court that must be maintained by deferring to the executive on the settlement question is the trust of the Israeli public. The Palestinian inhabitants of the occupied territories are subjects bound by the law, but bereft of political rights. This is, of course, the nature of any regime of occupation. But it is exactly for this reason that the international law of belligerent occupation strictly limits the powers of the occupying state. The authors write that the international law aims to provide members of the occupied population with the protection that they may not enjoy under domestic law of the occupying state. Subordinating the application of the norms of occupation law to the norms of regarding separation of powers in the democratic state and to trust of the public in the occupying state effectively deprives the inhabitants of occupied territory of the protection of international law. The question then looms large over the study is whether the court could have played a more positive and decisive role in saving Israel from the tragedy of the proliferation of settlements it now faces. Perhaps the answer was determined when the court ruled that Israeli settlers are part of the local population, turning international law on its head and legitimizing Israeli colonial practices. At present, at least one of the justices lives in a settlement, which happens to be Dolev, next to Ramallah where I live. Sadly, the High Court ended up giving international law a bad name and contributed to its demise. The most brilliant part of the book is the conclusion, because of its brilliance, of its balance, clarity, and thorough and convincing arguments that the authors put forward regarding the case of the role of the High Court. At the very outset, they state their claim that, quote, in its decisions relating to the occupied territories, the Supreme Court has legitimized virtually all controversial policies and practices of the Israeli authorities, including those that are incompatible with international law, unquote. These include deportations, house demolitions, and allowing wide-scale changes in the local law contrary to Article 43 of the Hague Regulations. But perhaps the worst was the court's refusal to rule whether establishment of Israeli settlements in occupied territories is legal. In their conclusion, they clarify that, quote, the court declined to rule whether establishment of Israeli settlements in the occupied territories is legal, but it granted its imprimatur to the settlement policy in various ways, which only include denying standing to petitioners who contested use of the public land for settlements, refusing to consider the legality of planning policy that promotes settlements, allowing time for the authorities to regularize the status of unauthorized outposts that had been built on public land, upholding amendments to the local law promulgated in order to cater to the administration of settlements, allowing the construction of the separation barrier on a route plan to include settlements on the Israeli side of the annexation war, and more. It is this last chapter that the last chapter that the authors also provide a review of the judicial tactics that the court has used to legitimize the government position, which, other than arguing non-justiciability, include disregard of international law, substitution of administrative law for international law, and obfuscation of facts. The other sections of the conclusion on the limits of judicial review and the court's mitigating role are both convincing and provide fascinating reading. I would sincerely like to end by thanking David Kretzmer and Yaël Ronen for providing us, the readers, with this accessible, scholarly work that gives measured answers to questions that are most often asked about the role of the Israeli High Court of Justice and its effectiveness or lack of it in protecting human rights and the rule of law. I highly recommend this book to all the viewers. Thank you.
Well, thank you very much for your response. I'm going to just let a bit of a give and take, but I want to perhaps push a point that Raja Shehadeh made sort of to provoke perhaps the give and take. It is understood to me that the relevant, the main thesis both of David Kretzmer and Yael Ronen is that while the court review enable many individuals to receive a remedy in cases in which their human rights were violated, many Palestinian individuals, it is ultimately served to legitimize the policy of the Israeli government. So pushing more further that point, the argument that Raja Shehadeh mentioned would be the following: might the court, could have the court have done more than this? Was there a way for the court, despite its limitation in its scope and its purview and the fact that it needs to be the public trust of the Israeli public, could it have addressed the legality of Israeli policies on settlement and the use of land? Might it have taken even a different approach and altered the occupation itself? So I'm just throwing this to both David and Yael, and allow you to, of course, respond to other points that Raja Shehadeh made.
Okay, thank you for that question, and thank you, Raja, for your wonderful comments and for your compliments about the book. I must say that you see the early years of the Supreme Court in a more positive light than I do, I'll be quite honest. I'm not so sure that there has been a deterioration. I think that from the very beginning, there were highly problematical decisions of the court. but you had the experience as a lawyer of using the court in order to sometimes get a remedy for your clients, and I appreciate that. Now, I have to answer Micheline's question, and I'm not sure how one relates to a question, could the court have done so? Clearly, from a theoretical point of view, from a legal point of view, the courts have said, we're not concerned with any outstanding, we're not concerned with our position in the Israeli public, we're going to rule according to international law, and so be it. But unfortunately, that's not how domestic courts act, and the Israeli Supreme Court is not unique in that. When it comes to matters of what are regarded as matters of conflict, regarded even of international relations, domestic courts generally stand behind the executive branch of their government. But I think the more important issue is this. In 1979, there was the famous Elon Moreh case. And Raja mentioned that case because that was the case in which Justice Landau said, I'm not prepared to rule on the general question of whether the settlements per se are lawful or not, but I can rule on whether the taking of the specific land of this individual for a settlement was lawful. And he ruled that in this case, it was unlawful. And therefore that the government had to remove all the settlers and return the land to the Palestinian landowners. This caused a total upheaval. There were threats in the political echelons to undermine the jurisdiction of the court to consider petitions from the occupied territories or to legislate in some kind of way to get round this decision. Rather than doing that, the government made a decision which was catastrophic. It decided that in future, all settlements would be built on what was termed state land, which is a misnomer because they assumed that the land would be land of the state of Israel, and public land in the occupied territories belongs to the people in the occupied territories. And then began a system which Raja knows more than Yael and I do because he's dealt with it, of declaring land to be government land, putting their hands on the government land, which is any land which is not being cultivated, and then establishing settlements. And the court then saying, yes, but nobody has standing to deal with this. So why do I say this? Because from a legal point of view, clearly the court could have decided otherwise. I do not know what would have happened politically if the court would have. And one thing that one has to take into consideration, at the time of the Elon Moreh case, 1979, 12 years after the occupation started, just 2 years after the Labour Party left power, the court still had a very, very high standing in the Israeli public, and its prestige was high. That is not the case today. Peculiar as it may seem to readers of our book, peculiar certainly as it may seem to people who read what Raja has written and hear what Raja has said today, in the perception of right-wing circles and religious circles in Israel, the court is not an acceptable institution. And the view among right-wing circles is that the court is pro-Palestinian. Pro-Palestinian. We write in the book that anybody who reads the book will understand that this is totally misfounded. But that is the perception. And the court is acting in an extremely antagonistic environment. It is attacked the whole time. One of the party of the present prime minister ran the election campaign of its party in one of the previous elections. I've lost count of all our elections. On the platform, take the power of the court and give it back to the people. So so you have to take that into consideration. Now, that's not to excuse what the court does, but it certainly can give an explanation from a political science point of view of why the court acts as it does. Now, I do not believe that the court could have ended the occupation. I do believe that the court has contributed to the continuation of the occupation. by legitimizing things in the eyes of certainly of the Israeli public, and as Raja mentioned before, allowing the Foreign Office every time to say, well, what do you want? The court has decided that this is legal. But on the other hand, I have no idea what would have happened if the court would have said, number one, listen, we're not dealing with it, it's not our issue, or on the other hand, would have started really deciding on the legality under international law, major Israeli policies, where in my mind, the court just wouldn't have lasted. First of all, I would have packed the court, as they're trying to do at the very moment. At this time, they're trying to pack the court with right-wing people. Raja mentioned one judge on the court who lives in the occupied territories. There's two, and I wouldn't be surprised in the present round of they're going to appoint judges, they're going to appoint a few more judges. And there's another judge whose brother lives in the occupied territory. So this is where we're going at the moment. So it's sad for me. It's very sad for me. It wasn't a happy moment. I discussed this book many times with Raja after the first edition, as he mentioned, meeting at lunch in Jerusalem. And I certainly appreciate his stand, and I do believe that the court has not upheld international law, but I'm doubtful whether it really could have done more than it did.
Thank you so much, David. Yael Ronen, do you want to add just a minute? I want to get the conversation rolling. And for those of you who have not yet asked, a Q&A is available to you on the bottom of your screen. Please make sure you can ask your question. So Yael, just go ahead, and I will.
Yeah, just one thing. That we always speak of the court not being willing to discuss the legality of the settlements, as if the only legal question involved is this a violation of Article 49.6 of the Geneva Convention, speaking about the transfer of civilian population. But actually, the settlement project involves various bodies of law, and both Raja and David have referred to some of them. And I think if the court could have made a change, it would have been on those issues, in possibly somewhat in the margins. So David spoke about the fact that the court said, we're not going to talk about the legality of transfer of population, but you cannot do that onto private land. Where it could have gone further was perhaps, yes, consider the legality of taking of public land. And David discussed the constraints of that, the limits of what it could do about that. Raja said it could have refused to regard Israelis as part of the local population. The court could have discussed the legality of changing the law in the territory, because that's also a constraint on the occupying power, and changing the law in the territory is required in order to establish the settlements, but the court was never willing to look into that. And everything that's related to planning and building, the court could have been stricter in its review of those issues, and that would not have even required it to go into international law. It could have done that under Israeli administrative law and reached other conclusions. And I think perhaps the most glaring, blatant refusal of the court to deal with what's in front of it is when claims of discrimination are brought before it, and the court does all kinds of acrobatics to avoid looking at the issue itself. And the settlement project is based on discrimination. I'll stop there.
Thank you very much. I just see questions appearing. Perhaps, Andrea, you want to pick one of the two? It's, I think, Charles Shamas's questions. It's a long question, so you want to read it? I haven't had a chance to go through it.
Okay, so this is quite a long question. I wonder if I might be able to synthesize it or shorten it a little bit, just in the interest of time. And so this is to Yael and David, kind of based on Raja's question, focusing on the role of the High Court. And so the areas of jurisdiction and powers ordinance of 5706/1948 appears to constitutively establish and define under Israel's legal framework the state's sole and exclusive sovereign competence to determine the manner in which any part of the territory of mandate Palestine was governed. And so, and there's some more details in there I think you all can read. And so he's asking that he assumes the ordinance is still in effect, and could it be considered to preclude any high court determination that the law is applicable to an extent and in a manner that would preclude exercise of the competence reserved by the state, and then there's some more ordinances. And so I think he's asking for you to comment on the various potentially overlapping or competing areas of jurisdiction and powers that would allow or not allow the court to engage in the occupied territories. As a non-legal expert, that is my reading, and I wonder whether you might choose to comment on this or maybe kind of clarify it for those of us in the audience who are similarly non-legal experts. So thank you.
I think if I understand correctly, the question is whether the ordinance from 1948 enables the Minister of Defense to declare that Israeli law applies and therefore preclude the application of the law of occupation, or preclude the Supreme Court from maintaining the law of occupation applies. And I don't remember the exact wording of the ordinance, but to the extent that the Minister of Defense, it authorizes the Minister of Defense to declare the applicability of Israeli law over any area of Palestine. And then we're talking about mandatory Palestine, which would include the West Bank and Gaza Strip. Perhaps it does, but the fact is that the Ministry of Defense has never done that. I mean, Israel has never claimed sovereignty or the applicability of Israeli law over the West Bank and Gaza Strip. Whether if it did so, even if that were valid under Israeli law, and I'm not sure we need to go back to the ordinance for that to happen. Maybe it can do that regardless. I mean, the government, under Israeli law, the government has all kinds of powers. Even if it did so, that would still be invalid under international law, which is probably the main reason why Israel has not yet declared sovereignty over the West Bank, precisely because it knows what the international implications would be. So the fact that Israeli law may allow this does not, that's not enough.
May I just add something that's very important? From the Supreme Court's point of view, it is not important whether Israeli law applies to territory or not. The theory of the Supreme Court, and under this theory, it exercises jurisdiction over actions of the military in the occupied territories, is that it will exercise jurisdiction over the acts of Israeli authorities wherever they act. In fact, the same question arose when Israel was in Lebanon, and cases were brought against the actions of the authorities in Lebanon, where Israel never attempted even to argue that it could or would at some stage apply its own jurisdiction. And the court said, yes, we have jurisdiction over Israeli authorities which are acting under law, and they never said which law it is, it doesn't matter, wherever they act. So that was the basis. So it wouldn't have made any difference whether Israeli law is applied or not Israeli law applied.
Raja Shehadeh, if you want to add something, or should we move to the next?
No, let's move to the next question. I think that the answer has been thorough.
And I'm going to just focus it just on you for just a minute. Likewise, could we say that the Palestinians could have taken a different approach with respect to the Supreme Court, as it's, after all the only court of appeal for Palestinian petitioners in the West Bank? The West Bank, for better words, is still a police state, at least because the security force, and I think you mentioned that somewhere where I've read, that does not seem to have any sense of accountability for its violations of human rights. So could there be a different approach from the Palestinian perspective? We know already what's happening on the Israeli side, and if so, what?
A different perspective towards the High Court, in other words?
The Yael Court, yes.
Yeah. Well, you know, there have been many stages and periods when there was a decision to boycott the court. But then, in a way, it has always been always the possibility that maybe this time it will be different, or maybe we can win something, or maybe it can mitigate some effect on if it takes the right decision. And sometimes, in the case of house demolitions, which has never been won, because the court has never accepted that house demolitions are not legal, they say that at least it will delay the demolition, and meanwhile maybe we can do something. So it has always been a temptation to go to the High Court, but there has never been pursuit of a common policy by the Palestinians towards the High Court. unfortunately. And maybe it should have been the case. Maybe the common policy should have been to boycott the court entirely and not to resort to it.
So let me just ask a bit, perhaps we'll move to the wrap-up questions and sort of push the reluctant optimist of David Kretzmer. So I'm going to ask the following. I think elsewhere, I believe Kretzmer wrote with a certain Professor Ishay that perhaps a confederal human rights tribunal and a confederal human rights commission could be more impartial. I was wondering, what are your thoughts about this today? And perhaps others want to jump in, and we can take another question at the end if there is one, and wrap it up, because I know it's 10 p.m. In Ramallah and Jerusalem.
Who's the question directed to?
Well, first to you, because I know you've written it in collaboration to the sinner on the other side. So.
Look, I sat on an international semi-judicial body for many years, and I have to be somewhat skeptical about the possibility in a case of extreme circumstances that you could have a tribunal which would be accepted by both sides, which would be legitimate by both sides, and at the same time would be objective and neutral. I still think it should be tried. I think that eventually, I do not believe that the two-state solution is anymore on the cards. We're going to have to at some stage work out some kind of confederation between Israelis and Palestinians, so that everybody should enjoy all their international human rights. And then we will have to think of some human rights tribunal, but it's very difficult to perceive of it at the moment.
Okay, so that's great. Raja Shehadeh, do you want to make a final statement? Just perhaps one short for each of you.
Well, I think that the main problem is that there continues to be a denial of the Palestinians as a people. And as long as Israel denies the existence of the Palestinians, and the latest denial was by Naftali Bennett in the court in the Assembly, General Assembly, UN General Assembly, when he didn't mention the P word once, and went back to the Golda Meir's statement that there are no Palestinians. As long as there is no recognition of the Palestinians as a people, then we cannot begin to work things out. And once that recognition, the mutual recognition between both begins, then we can think of tribunals, and we can think of how to deal with the past, which is a very bitter and dark past. But there's not even the simmer of hope that anything of the sort is happening, or that there is preparation for anything like that to happen.
Okay, thank you very much. Yael Ronen, you want with the last statement? I see that there is an additional questions, and I don't know if we will have the time to read it, but I would strongly encourage the person who asked the questions to connect directly with the panelists if she wish, if they wish later on. So Yael, you have the last word, and then Andrea can wrap it up.
Okay. I'm not more optimistic. I think any joint legal institution requires that's not the first step. It's something that requires trust and cooperation that we're so far from. It's too far. But if I may actually relate to the question on the screen about the fact that Palestinians can no longer appeal directly to the Supreme Court. So it's true that on certain issues, legislation requires that on certain issues, rather than appeal directly to the Supreme Court, the matter has to go first to the district court, sitting as a court of administrative court. But then there is an appeal from that court to the Supreme Court. So it's not that the path has been closed, and the body of law is technically the same body of law. So it's not entirely accurate that it's not that there's no more recourse to the courts, although the fact that it goes through the district court does complicate things to some extent. And it's true. For example, it imposes extra costs. Yeah.
Okay, thank you very much, Yael, for the last point, and also thank you for responding to this the question. I think this is we are just warmed up. It's 10 o'clock p.m. in Jerusalem, and we are not going to continue the party, unfortunately. But this perhaps requests another sessions with more questions about how there is a bridge between the legality and the political situations. But I will let Andrea Statten, who is our acting director of the Center of Middle East Study, to just give the final statements and to Fair as well.
Yes, this is a hard party to be part of, and I just want to say how much we appreciate all three of you for your work in this area, and thank you very much for joining us today or this evening for this really timely and challenging work, raising some of the critical issues around governance and occupation in the West Bank. Really appreciated your insights. Thank you for sharing them with us, and thank you for David and Yael for this book that you've produced, and thank you, Raja, for your work as an activist and scholar in your own right. So, and thank you very much, Micheline, for guiding us through this really rich set of conversations. So thank you again. We'll close now, and thank you to all of everybody who joined us, and thanks very much to our Korbel team for making this possible. So.
Yes, thank you, Dustin and Anna, and goodbye, and see you.
Thank you.
Yes, thank you.